Revocable trust versus irrevocable trust is probably the question I get asked most often by clients. I'm Greg Nussbickel. I'm a Florida probate and estate attorney. And the answer to which one is right for a particular client isn't about better or worse so much as just two totally different sides of the equation. So, the revocable trust is the most common one in Florida. It's the estate planning vehicle that allows the individual who creates it, called the grantor, to continue to hold all the cards. They have access to their assets, they have control over them, they can spend and sell and buy new assets really without consequence. It's tax neutral and they're free to change or amend their plan anytime they want. So, this can be a really flexible way to accomplish several important goals. One would be you can avoid probate with the revocable trust. The assets that are titled in the trust aren't going to need that court administration after the individual dies. You're also able to add some protection to the distributions that are being made to beneficiaries. So after that grantor is gone, let's say their children are beneficiaries, they're going to have some protection against creditors that they may have or divorcing spouses or what have you. And the revocable trust is going to allow for incapacity planning as well. The trustee that they've named can step in and take care of them during their lifetime. That's why you hear it called a living trust. It is effective during life, and that can be a really big benefit. It can avoid a guardianship proceeding in the courts, for instance. And with a revocable trust, you don't answer to anybody else. There's no one with any vested rights. There's no one that you have to report to or anything like that. The trade-off, though, is if you can reach your assets and you have total control and you can change your mind, then that probably means those assets are exposed to creditors. So if somebody sued you, the assets in your revocable living trust aren't going to be immune from that lawsuit just because you own it in the trust. And it's also, because it's tax neutral, not a tax planning device like the irrevocable trust might be. So with an irrevocable trust, as the name suggests, you're actually giving up control. You're no longer the one in charge of these assets that are in the trust. You're also not the beneficiary. You're not entitled to receive benefits from these assets that you used to own yourself and enjoy. And you can't change your mind. That's how you want to think of the irrevocable trust planning. Although that last part isn't quite set in stone, even irrevocable trusts can be revoked or amended under some circumstances. Sometimes that would be a court order or some universal agreement of the beneficiaries that could even change your quote unquote irrevocable planning. But those types of trusts can do what the revocable trust cannot. The revocable trust can't help you with estate taxes in the future or shield the assets from creditor claims, that kind of thing. So, as most planning does, this all really hinges on the goals and concerns that you might have. So, if there are questions about modification or reforming these things or which one's best for you or how they each work, feel free to let our office know and we'll do our best to help you out.